Sorry, it's been a while since the last video. We've had a very eventful few weeks here, so things have been moving right along. This is not, although this is the third video in our series, this is not episode 3. This is an addition to episode 1, like an addendum, if you will. In episode 1, we spoke about judicial review and the rules for judicial review, and something has come up since that video that I really need to bring to your attention, because the whole point of this video series is to show you how ridiculous and unreasonable the Canadian government and specifically IRCC has been with regards to Widlene's case. So this one here is very interesting. I mentioned in the first video that along the way there's a point where we can ask for information on the file, all the communication, all the emails, phone calls, whatever's been logged on this file in the government database on the government servers. We have access to that, and that's just the thing that exists. It's called ATIP, Access to Information and Privacy. Now let me read you. Basically, here's how it works. You spend $5 and you ask for all the information that's been passed around on your name or someone else's if you're the representative. And they go through these emails and anything where you've been mentioned in government communication, they send it to you. Okay, so let me read you something from the website, IRCC website, where it comes in the ATIP section. Should come up on your screen here. Who can make a request under the Access to Information Act? Canadian citizens, permanent residents, and individuals present in Canada can make a request under the Access to Information Act. If you are none of the above, you can ask a representative who is a Canadian citizen or permanent resident to make the request for you, if you give that person written consent. Now, Widlene obviously is not in Canada. She is not a Canadian citizen. That's important. These guys know she's not a Canadian citizen because we're applying for her to come to Canada. So Widlene is the applicant on the TRP application, and she has a representative. A representative is a lawyer. Our lawyer is from British Columbia. He's listed in his law firm as Widlene's representative. Not me, but this lawyer. That's Widlene's representative. So, according to this, he can apply for an ATIP on her name, and it's all good. So we did that. And in episode 1, I read to you that our lawyer sent me an email saying they don't want to give us the information. But since then, I've got my hands on the original email from IRCC, and it's good enough that I felt it merited another video. So should be on your screen. This is further to your request under the Access to Information Act, which we received on May 13th, 2019. Following records, the electronic notes, and this is the parameters that we asked for under Widlene Alexis. We regret to inform you that we are unable to process your requests for the following reason. This is the important part. In order for us to release the personal information of the minor in question, we require proof that Crystal Dawn Earl, Baden Terrence Earl, Terrence is my middle name, are the legal guardians of Widlene Alexis. Okay, so we've given them guardianship documents already. They have those. The custody agreement, wait for it, must be a Canadian-issued legal document and must not be older than 1 year. Okay, so then it says if we've not received your reply by July 15th, we'll consider the request abandoned and close our files accordingly. There's 2 problems with this. Problem number 1, Widlene is not a Canadian citizen. They know that. A custody agreement, a Canadian custody agreement cannot be granted to a non-Canadian citizen. So, according to the ATIP rules, she can assign a representative who is then allowed by law to get the information. Whether I or Crystal are her guardians is irrelevant. We're not relevant in the application at all. We're not her representative. They're not acknowledging us as guardians or parents. So why are we brought into this? If XYZ law firm has been assigned as the representative and XYZ law firm applies for the ATIP, it should be irrelevant who her guardian is at that point, since XYZ is representing her. That's interesting. The other thing that's interesting is it says the custody agreement must be a Canadian issued legal document and must not be older than 1 year. Now, Ahmed Hussein, you may remember, on TV said that a reasonable turnaround time for an emergency TRP is about 30 days. And this is why he's been pissed off with me for the last 2 years, because I got him on camera saying that, and he lied. Now, we got our rejection, I think it was 16 months after we applied. So this right here is a month after the rejection. So they send this now 17 months later, and they say the Canadian custody agreement must be, wait for it, no more than a year old. So that still lands within the time that we had an open TRP application. It's absolutely impossible for us to obtain a Canadian custody agreement within that time frame. You're not allowed to do that. That's having 2 open applications. It can't be done. It's not just physically impossible, it's chronologically impossible, and it's legally impossible. This is the nonsense they're giving us every single time we turn around. This is garbage. This should result in an automatic judicial review, because they've broken their own rules here. I read you the rule, I read you what they wrote. This is the crap we deal with every day. This is the people we voted in to lead our country, and we have to call them out. Check out the next video.